especially railroad projects. This project is the construction of a new railroad in Utah,
Hmm.
and take them through the regulatory process and through the NEPA environmental review process. And so Catherine and a team here at Venable who worked with her spent 3 years taking this project from nothing to a draft environmental impact statement, a final environmental impact statement, and then an approval from the Surface Transportation Board, which is the federal regulatory body that approves new rail construction.
Hmm.
That's where I started getting involved because there were some people who didn't want this project to happen and they were willing to sue about it.
Mm.
And they sued the Surface Transportation Board
Okay.
and the DC Circuit Court of Appeals. I got involved to help defend the project. And in the end, we lost a few points. We won a few points, but we lost some important points in the DC Circuit. That's what set up the Supreme Court process.
Okay. So what was the DC Circuit's decision? How did you what did you win? What did you lose?
So there were a whole sort of shotgun blast of challenges to the project in the DC Circuit. The ones that are most important for our purposes here today were the challenges under the National Environmental Policy Act. What we lost in the DC Circuit was basically three things. Number one was the DC Circuit said, well, sure, the Surface Transportation Board's review acknowledged that this project could uh, trigger more oil wells to be drilled because the train would be able to carry oil.
Hmm.
Maybe more oil wells are going to be drilled in the Uinta Basin where the project exists. Um, you acknowledge that, but you needed to do more detailed study. That
Hmm.
was number one. Number two was, well, once the trains go off of this new rail line and they go along an existing railroad line through Utah, through Colorado, on their way to destinations where the oil could be refined. What if there's an accident? What if a train derails and there's a spill? Yes, you acknowledged again the STB had acknowledged that possibility, but it had never drilled down to the level that the DC Circuit wanted it to. And then the third thing was once the oil is brought out of the basin and goes along this other rail line, it has to go somewhere to get refined. And the STB said, well, most of this oil will probably go to the Gulf Coast, where there's a number of oil refineries in Texas and Louisiana. And the STB again acknowledged that, but it didn't explain in detail what localized effects might happen to communities near refineries.
Okay.
So those were the three big things that we got dinged by the DC Circuit on and that were up before the Supreme Court today.
See what so Jay isn't saying, Nick, of course, is that every glory of appearing before the Supreme Court is built on the foundation of a crushing defeat.
Right, right.
You don't appeal to the Supreme Court, you get the Supreme Court. You have to lose a little to win a little.
Right,
You know,
right.
and so in this case, the DC Circuit was the only court that reviewed this, first of all. So some people think, why did it go straight to the DC Court of Appeals? It did that because that's the way the statute works. Review from the STB goes directly to the DC Circuit. So
Okay.
only one step below the Supreme Court.
Right, right.
So yes or no, win or lose, the only other step after that was the Supreme Court. But we wouldn't have
Right.
been there if the DC Circuit ruled in our favor all the times. We might have been on the other side of the V, but because there were some things that we didn't agree with, that's why we sought review in the Supreme Court.
Okay, so I mean, and it was like a listening to the case this morning. It sounded very complicated. So when you get involved, like how do you begin to say, okay, we're going to the Supreme Court now what? So what's step one?
Well, step one is actually getting heard by the Supreme Court because people may or may not know there's no automatic appeal from the Court of Appeals level, the one step below, to the Supreme Court. You have to do what's called filing a petition for certiorari. It's basically asking the Supreme Court to review your case, and to persuade them to do that, you have to sort of sell them that there's a problem, not just in your case, but in a whole variety of cases, so
Right.
that they should take this case and solve that bigger problem. And the court hears about 60 cases every year, and it gets about 6,000 requests.
Right. So this is a big deal.
So it's not easy to get from you lose in the Court of Appeals to, okay, now the Supreme Court's going to hear it.
And so, did you think that this case, were you confident that the Supreme Court would hear it, or were you hopeful? So those are two different
I
things.
think you'd have to be crazy to look at the 60 out of 6,000 odds and be confident.
Right, right.
No
Like the
one.
Jets on
Yeah.
any given Sunday, you
Could
hope
they win?
you
Yes.
hope they could win, but you're never confident.
Right.
Right.
I mean, I told somebody this morning, they were asking me essentially the same question, and the way to persuade the Supreme Court is to find what they call a circuit split. It means that the D.C. Circuit Court of Appeals decision that we lost it contradicts some other circuit's decision.
Mm-hmm.
That's the clearest way to tell the Supreme Court, hey, this is the problem you need to solve. If you have a case in the D.C. Circuit, you get this outcome, but if the same case came in a different circuit, in a different part of the country, the opposite outcome would occur.
Right.
That's the kind of problem that they sort of exist to solve, right?
Right.
And it has to be an important problem, not sort of a minor, quibble. You got to tell them there's a disagreement among the circuits and it's a big deal.
Right.
So when we were thinking about what to do with this case after we had lost in the DC Circuit, I was looking for this kind of a disagreement, and I found a case in the 11th Circuit that was called Center for Biological Diversity against Corps of Engineers.
Mm.
And in that case, the Court of Appeals criticized the DC Circuit's test for the NEPA, the way that the DC Circuit handles NEPA. And when I saw that there was an explicit criticism in another Court of Appeals of the way the DC Circuit did it, I thought we have a chance.
Right.
So we went from there.
Very interesting. Okay, so when you find out that it will go, is it?
Well, there's a story about that.
Oh yeah.
I
Okay.
mean,
Tell me.
the month before we found out, so that was June of this year. You're down, that 1%, 60 out of 6,000.
Right.
But as the Supreme Court's term comes to an end, the number of petitions for certiorari gets smaller and smaller and smaller because they've disposed of them. Again,
Yeah.
the vast majority get denied, and then a few get accepted for hearing. Well, all of a sudden, in June of this year, because our decision hadn't been issued about whether our petition was going to be granted or not, the universe of cases that remained left for the court to consider was starting to get smaller and smaller and smaller because
Right.
we were considered at the very, very end of the term last June.
Yeah.
And so every week, Jay and I would talk, and we'd be just doing the math.
Right.
There's only so many petitions left.
Right.
They've already accepted X number of cases. We guess how many more cases is left based on how many cases they hear every term.
Yeah.
And so every week we would update our math. And it was 10% because there's only so many cases left, and then we survived that week, and a lot of cases got dismissed, which up to 20%, 30%,
Mm-hmm.
and then finally we were listed for conference for the decision on whether the petition would be granted, and we were waiting for the order, and they decided to hit us again, like push us to one more conference.
Right.
Well, once we heard that, then our head started spinning, and the percentages started going up. Because as Jay explained to me, in recent years, before the court grants cert, they often hear a cert petition at multiple conferences.
Oh.
And so now all of a sudden we were at our second.
Yeah.
And in addition, many other cert petitions have been denied. So now our odds are getting up. So by the time the last week came along and we were waiting for that order to come out on our cert petition, we were up to a 35% chance just based on the number of petitions that were left to be heard.
Right.
And the number of slots. So we went from 1% to 35% just that last week. And so all of a sudden we went from, we hope because those odds are crazy to, this is getting fairly close to a coin flip. And that that's pretty good odds for a
Right.
cert petition.
Right. Okay.
Once we went to the second conference, we were a little more than hopeful, more like fingers crossed optimistic.
That's yeah. Right. And so okay, so what is like the core argument here for the case? I mean, obviously it's complicated. There's lots of different things. But you're talking about acknowledged but not detailed is something I heard three different times. So but on three different very different things. Do you consider that as like what we're going to be deciding is how much detail we need to go into about each of these individually? Is it just, first of all, we need to answer the question, does an agency or are they required to do this, period, let alone for specific things that we see in this case?
Yes, I think what you said there at the end is exactly where most of the argument was today. Like, yes, the STB did a lot of acknowledging and it had a broad range of things. Its EIS was 3,000 pages long. The question today was more, does it really need to be that long in the first place? The DC Circuit seemed to say, well, it should have been 5,000 pages because
Right.
there's a lot of stuff you didn't do.
Right.
But I think the tone of the questioning today was more, didn't they just amend NEPA to say that these statements need to be, 150 or 300 pages? And how in the world can you realistically do that
Right.
the way that NEPA is interpreted today, the scope that courts have given it, or at least what the DC Circuit has given it?
Yeah, and so when you're building your argument, because I mean, I don't know. First, I guess maybe I should ask, like, did what you plan for, what you both planned for, what you all planned for, play out the way you thought it would?
I'd say yes, in a sense. I mean, there was a process, and we were working with Paul Clement, who's, one of the best, if not the best, Supreme Court advocate in the country. I think today was his 118th Supreme Court argument. He was a former Solicitor General. He was terrific. So we were working with Paul through, over the course of months to refine our arguments further and further. And I think it really came down today to a test that, Paul and the two of us kind of worked out. Here's the test, because that's what the justices were ultimately interested in.
Right. They
as
asked
it
a
turned
lot,
out.
a lot. They asked about that a lot.
The Clement test, they kept calling it.
Yes, they did.
Which is always a good thing when they're
Yes.
naming the test after the lawyer on your side.
Right.
That's always a good thing. I mean, my response, Jay, is that I think the case played out a little bit differently than when we first anticipated it. And I think in part that's the beauty of working with somebody like Paul with all that experience from the court.
Hmm.
Again, Venable, we've been involved for 5 years, multiple years. We're passionate to defend the client to a certain extent. We just want the railroad built. We
Yeah.
want the client to be able to fulfill its vision and its mission.
Right.
But once you get to the Supreme Court, there's something more at play,
Right.
right? And what Paul was able to build into the arguments that we had crafted from the cert petition and then on to the merits briefing was that more, that a little bit extra.
Right.
And so, I think we said this many times, the court didn't take this case to affirm the DC Circuit.
Right.
They're not taking a case if they think everything is hunky dory.
Right.
So if that's the situation and there's a possibility of reversal, the question is how should there be a reversal, on what terms? And I think what Paul was able to build into the arguments that we had crafted originally and then we all settled on was what would that more look like?
Right.
Right. So we want to win,
Right.
and there's a lot of ways that we could win, but there's also an opportunity because obviously something's amiss.
Right.
With the DC Circuit and the Ninth Circuit ruling in different ways, and EIS is still being too long, and Congress having to step in to make them shorter, and throwing that all into a tizzy.
Right.
Obviously, there's room for the court to give instruction to the government and everybody involved in the NEPA process generally to say, okay, here's a reasonable set of limitations that still fulfills the mandate of the statute, but also stores some sense of reason
Right.
to this process. And so to me, where I think it's different from where we started is that we were able to settle on at least some guidance to the court on what that might look like. We might not have had that in mind. We were just trying to get in front of the court.
Right.
But once we were there, I think it became a different ballgame.
Yeah. Go ahead.
Yeah, no, I think that's definitely true. I mean, it's a process in a way that maybe it's not in the lower courts because there's more big picture policy at stake. You know, the Supreme Court, if it's going to make a decision, is going to want to make a decision that not just corrects the error in our case, but that explains to future agencies and future courts what they should be doing instead.
Right. And you know, I before I really start diving into that, like the argument, Paul got justices to laugh. I don't know if you noticed that, but that happened almost right away, and I was like, I didn't know that was a thing. And I'm not saying, I don't mean it to be flippant or coy. I just the ease with which it's like they all knew each other, and so that was kind of really interesting to see that back and forth. And like I think I can't remember the Sotomayor who was like, I'm trying to help you out. He's like, yeah, I appreciate that.
Yeah,
Whatever it was, it
or
was
Kagan
really
saying, when he said, Paul said, if I could define proximate cause, I'd get tenure at Harvard.
yes, that was it. That was
And
it. That's
Kagan
exactly
chimes in
it.
and says, I think they'll give you tenure
Anyway,
anyhow.
yeah, right. Which was pretty
Well, that's
funny.
kind of the value of partnering with somebody like that, isn't it? I
Yeah,
mean, it's you're standing up with confidence and familiarity with not just the individual. It isn't that they're they're drinking buddies or something,
Right.
but it's confidence that what this individual is telling you can work within the rubric of how the court decides cases.
right,
The advocate gets it.
right,
I'm here. I know what you're thinking. I know what you're struggling with in terms of writing an opinion. I'm going to help you get there. And it's that element of trust
yeah,
between the bench and the advocate to say, okay, you're not going to lead us astray. You're
right,
not going to lead us down a path where we're going to write an opinion that's going to be Looney Tunes. You're trying to solve a problem, and you're going to help us get there.
right,
And I think, as you pointed out, not just the familiarity and the comfort, but also the multiple questions that were like, help us craft this rule.
right.
We'd like to hear what do you think? What the rule should be? If you're getting questions like that, that's just invaluable because then you're viewed as assisting the court. You're an
Right.
advocate, but
Right.
you're also helping the court.
Right.
Sure.
Yeah. And I think one of the things that I've heard from a few people that was kind of confusing. It's kind of I think there is a understanding, like, an agency cannot review everything, but how do you define, like, how do you actually say, okay, what is far enough away, both temporally and, spatially? What is far enough away? And how do we do that? And I don't know if that's an answer you can actually give because it's really subjective. But the court seemed the very interesting thing to me is that they seemed to be almost in agreement with each other, all of the justices. I don't know if there was a lot of disagreement. Would you agree with that?
Yeah, I think so. I mean, I was a little surprised by that, I guess, frankly. I thought there might be more pushback between the justices even, but I took that to basically be a sign that, you know, yeah, it's a hard question. How far is too far? But studying refineries in Louisiana for a project in Utah, that's too far.
Right.
So once you've got that kind of locked in, and they didn't obviously say that, and who knows what they'll hold in the end.
Right.
But I think there's a sort of common sense to wait, well, if you agree you can't study everything, like how much farther do you have to go than 1,000 miles away? That's a big deal.
Yeah.
So I
And
think, yeah, go ahead.
so you're not arguing, you guys were not arguing that you should never look at any indirect effects. It's just there's a limit to how far the scope and scale of a project can go.
That's right. I think something that Paul kept emphasizing that we, even from the earliest stages in this case, really wanted to emphasize is that you really have to anchor your analysis to the project itself.
Right.
Like start with the project that you're trying to approve and keep the focus there. It doesn't mean you can't go beyond it at all, but once you start getting to the point where there's like 3 or 4 or 5 steps beyond the project before you get to the effect, you need to start asking yourself if you've gone too far,
Right.
especially if you live in a world where the EIS has to be 300 pages long.
Right.
Right. And the justices pointed out today that even if you're focused on the project, like the air pollution from a project, it drifts. It
Right.
drifts beyond precisely where the project is. So of course you have to look at that. And I
Right.
think we conceded, yes,
Yes.
that is correct. But the thing that I think a lot of folks worried about is, oh, the opinion's going to come out and we'll never do indirect and cumulative effects again. And I disagree with that vehemently,
Right.
because even the current formulation of those effects under the regulations are framed in the context of the project.
Right.
It's not just indirect effects. No, it's indirect effects
Of
caused
the
by
project,
the
yeah.
project.
Yeah.
It's not just cumulative effects. It's the incremental effects of the project in
Right.
the context of other past, present, and reasonably foreseeable projects. Everything is focused on the
The
project. So that doesn't eliminate indirect and cumulative effects. No way. It just says, let's keep the focus where it should be and not just on a generic assessment of indirect effects or a generic assessment of cumulative effects. There's a reason those words are in there.
Right.
And I think that's what came through with the argument today. I mean, they pressed our side to say you can't just mean that you put blinders on at the 88 miles. And the answer was no, we're not. We understand that there are other things that are relevant to it. But if it's grounded in the project and what's, the legally relevant cause of the effect from the project, then that seems to be a rational test.
Okay. Yeah. And it's funny. So I also want to clarify a few other things. So I know that they kept bringing up deference, and we've talked a little bit about Chevron deference, and I know that's not the same thing. So I don't know. Could you also break down what they meant when they're saying all kinds of times they brought up deference to this, deference to that? What does that mean? What do they mean by that?
Yeah, I understand why it's confusing, and I think maybe sometimes the justices were bringing up deference because of Chevron, and they're kind of poking at each other a little bit, maybe.
Okay.
But I think the way I would conceive of it is Chevron deference is about deference to legal views of the agency. The deference we were talking about today is more about deference to the agency's expertise as a fact finder.
Gotcha.
So, if you're an agency and you are studying how many rail accidents might happen and you choose to use a certain set of data, in our case, the DC Circuit said, well, that was the wrong set of data. You should have chose a different set of data. That was not deference. That was the opposite of deference. And I think it seemed to be fairly uniform among the justices that, there should have been more deference there. And certainly
Right.
the government, which also argued today in support of our view, very much thinks there should be more of that kind of factual deference. It doesn't have anything to do with the agency's legal powers or its interpretation of the law. It's just, hey, these people at the Surface Transportation Board are experts on rail effects, and we should listen to them.
Right.
Yeah, and what was one of the more telling comments from the bench was Justice Kavanaugh today,
Right.
who mentioned that in light of the Builder Act, the most recent amendments to NEPA that reduced pages limitations and time limitations for doing NEPA documents, his quote was, this seems to me to require deference times two. Because if it becomes harder for the agencies to narrow the scope of what they should be doing, if they have to write shorter documents and more, focused documents, he says that would seem to me that would be even more deference to the expertise of the agency. And to hear, a conservative justice talk about that,
Right.
and just Justice Jackson, arguably the most liberal justice on the bench, also talking about deference in that way, that's pretty telling.
Right.
Right. And so I don't think there was confusion on the bench about Chevron. There was echoes of Chevron because it was a big deal. And Paul, our colleague, was also involved in the arguments on that case last term.
Oh, wow. Okay.
Yeah.
Yeah.
But no, I think there is a distinction, and I think it could be actually very helpful if the court makes sure to clarify that, especially for the lower courts.
Gotcha.
Because I could see lower courts around the country, because judges on the district court level, especially, may have one or two NEPA cases every 3 years.
Yeah.
And so they need more guidance in some ways about what am I deferring to and what am I not deferring to and what does it mean. So it actually might be really, really helpful if the court in the course of its opinions add some clarity to that, not just answering layman's questions like yours, which are excellent, but also practitioners' questions at the agencies, and then judicial questions on how we deal with this when there are legal challenges.
Oh, are there going to be more legal challenges?
Never. No.
So they also brought up Sable Trail several times. Why do they keep bringing that up, and does that have a connection? to deference.
So
Chevron deference.
Sable Trail is the case that the DC Circuit relied on in our case to basically say, you didn't go far enough. And the way that our briefs framed it, and credit to Paul on this, is he said Sable Trail creates a no good deed goes unpunished rule.
Right.
So if you see an effect, this is kind of to what I was talking about earlier. The FTB identified potential effects in Louisiana or upstream in the Uinta Basin.
Mhm.
If you see anything, you have to study it to the nth degree.
Right.
And our view was no. If you see something and you identify it, good for you.
Right.
But if it's outside the scope of what you have to study in detail, then you don't have to do anymore.
Yeah, so SUNIPA should not be like Homeland Security. See something, say something.
Right.
It should not be that.
Right.
That should not be the rule. And, I think what Jay and I have seen over the course of our careers is that, when an agency identifies an effect,
Yeah.
determines that it's not that big a deal, they'll only write, just a little bit.
Right.
They'll identify it, they'll talk about it briefly, and then they'll move on. There's no technical report, there's no appendix, there's no study about it. So what happens in litigation? The other side picks that very thing.
Right.
In my career and when I've taught, I call it the underbelly of your NEPA review, the soft underbelly of your NEPA review. That's what the other side looks for.
Right.
What are they concerned about that maybe you rejected from detailed review that you identified? And that's part of the problem in the litigation, that an agency can make a rational choice. This is not something we should review. We don't think it's a big deal. The other side, you should have done more.
Right.
Or what's even worse, and what we pointed out to the court today, the worst case scenario is that you pick out something that's remote. You decide to scratch it at a little bit more even.
Yes.
And you get challenged. Even that isn't enough.
Right.
You should have done more and more and more and more. And that's the frustration that project developers, in any industry, whether it's renewable energy or oil and gas or whatever, that's the frustration that they have is like, if we're trying to do a good thing, the no good deed goes unpunished,
Right.
and provide some additional information to the public or whatnot, we shouldn't get dinged for not writing 150 pages about it.
Right. And is the opposite a concern for you? So where an agency says, well, yeah, we looked at it and we don't think it's relevant at all. We're good. We don't have to do anything. Why are we even doing NEPA, actually, as a matter of fact? And we just move on. Is there a concern that people will take that thought and go, well, we don't think it's related. So is it? Is there a concern there?
Well, I think you're getting more at the line drawing problem. We're certainly not saying that no one has to do NEPA. I mean, there was an interesting few questions from Justice Kavanaugh where he kind of was asking, well, when NEPA was passed in 1970, there really weren't any environmental laws, not the way we think of them today. The Clean Water Act hadn't been amended. The Clean Air Act was still in its infancy. Like, it was a different world. And now that there are all these other laws, he seemed to be asking, well, what's the point of NEPA? We've got all these other laws, just follow them.
That's when we heard gasps
Yes,
in the audience
yes,
behind
I was
us,
about to
Nick,
say,
from
yeah.
the CQ
Yeah.
folks that were there. They didn't like our
Right.
question.
But our answer wasn't, well, you're right, there's no point in NEPA.
Right.
Because
Right.
NEPA still does have an informational point. It's supposed to help the agency understand the effects of its action.
Mm-hmm.
How far do you have to go in deciding what the effects are? That's the hard part that we were trying to sort through today.
And what we pointed out in this case, and this is true in every case that you've been involved in too, the STB looked so carefully at this project that in one instance it decided to, move the tracks a little bit so it avoided noise impacts to 6 homes.
Right. Right.
NEPA, if nothing else, involves application of the Holy Trinity, avoid, minimize, mitigate.
Right.
And it's at the heart of the EIS is an alternatives analysis to try to, avoid potentially, if you can, harmful effects.
Right.
And I think what we pointed out to the court was in this case, the process worked.
Yeah.
That's exactly what they did. A lot.
Right.
To the tune of dozens and dozens of mitigation measures.
But there was nothing that the board could have done with the project in Utah that would have avoided effects in
Right.
Houston or Louisiana or wherever, because those effects weren't being caused by the alignment of the railroad in the 88 miles that we were proposing to build.
Those
Yeah.
refineries exist already.
Yes.
They're already refining gas. It's already, so when is our stuff going to get there? How much is going to get there? Is that refinery even still going to exist at
Right.
that time?
Right.
You know, so would our materials substitute other materials so the quantity of refining would be the same? I mean, all
Right.
these unknowns added onto the uncertainty and the value of the information that would have been offered if that kind of study would be done. I think we tried to point out. So one, you can't discriminate against the cargo
Right.
as a matter of law, STB. That's, I think, what we were arguing, and many justices picked
Yeah, I
up
was about
on
to say they
that,
all picked up. I heard
including the
that
liberal,
several times. Yeah.
including the
Yeah.
liberal justices.
Right.
And the second argument would be, well, then on top of that, even if you developed a study, the most elegant, beautiful study
Mm-hmm.
about refining impacts in Louisiana and Texas, what does it mean?
You're right.
What value does it add to the bottom line decision of the agency? And what value does it add to the general public when the basis for that information is so gosh darn uncertain?
Right.
So, we didn't think there was much in the way of, potential harm in that scenario.
Yeah. Yeah. And so you guys, you presented your argument. Was there anything? Is there anything that I haven't asked you about that you want to kind of point out that we've? Because I want to get into because there were two other people that spoke, and I want to talk a little bit about that too. So, anything else from your argument that you want to kind of maybe have an additional point on?
Well, I'll just touch a little bit on what Fred just said about what they call the common carrier obligation at the Surface Transportation Board. What it means is that by law, a railroad can't say no if someone tells them, "Hey, I've got something I want to ship. Here it is."
Right.
There's really no way for a railroad to turn that down. So if your customer says, "Here's some oil, take it over there," you have to do it. If they say, "Here's some wheat," you got to do that too. And I think it was interesting that a lot of justices latched on to that point as maybe a reason that studying the effects of the thing that's being carried might not be relevant to the Surface Transportation Board's decision.
And that has currency for a lot of different examples. Like the Federal Highway Administration can't decide not to build an interchange because of the potential indirect effects of the development that would occur at the other end of that interchange. They can
Right.
acknowledge it, they can
Right.
study it, but they have no way to control it.
Right.
They don't know if the development will happen or not, if the market for the townhouses will still be there, or the movie theater or whatever might be planned over there. They can acknowledge it and talk about it,
Right.
but they can't say, you know what, this world has too many movie theaters, so we're not going
Right.
to build this interchange.
Right.
I mean, the concept that we heard today on common carriers, I would argue, has currency for a lot of other agencies as well. The other thing I'd add, and I'm curious what Jay thinks about this too, what you didn't ask,
Mm-hmm.
is that the argument that Paul made today was not the argument where it started.
Right.
We had prior to the argument 2 moot court sessions
Yeah.
where groups who are helping out get really 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 smart people to play the roles of justices and ask really hard questions and listen to the responses and then provide feedback on whether they thought the responses were good, on
Good.
target,
Yeah.
clear or not clear.
Not clear. Yeah.
And being a part of those moot courts was almost as invigorating intellectually as a professional as it
Yeah.
was being a part of the argument today, because you can witness the evolution of an argument on Sirius XM radio on the Beatles channel. They have this great segment called "Say You Want an Evolution,"
Right.
and they
Oh,
give
yeah,
you
yeah.
the evolution of a Beatles song from the initial melody to all the tracks and whatnot.
Yeah.
We saw the evolution of the argument
Right.
from where it started to where it was delivered today, with the benefit of the help of all these really smart people. And I got to tell you, it wasn't the same.
No.
It
Okay.
wasn't the same from where we started. Obviously,
Right.
there were similar themes and
Right.
whatnot, but the way it was refined, sorry for the pun with our case, but the way it was refined and what happened was just fascinating. And I don't even think if Paul were sitting here, he would disagree.
Right.
It was better today than it was the first time,
Right.
because you
Right.
get the benefit of all the feedback from people. That didn't make a lot of sense, or oh, if you say that, there's going to be this problem or that problem,
Mhm.
or if you say that, you might get the ire of one judge or another judge, so maybe you should avoid that or whatever. And those sessions were unbelievably fascinating, and in my view, played a huge impact on what we heard today.
I agree completely. They were fascinating, and that the argument evolved. I mean, I think that's how it should be, right?
Yeah.
That's why you do these moot courts. But I would add one other little thing, which I think is that in some ways it all came full circle back to where we were when we filed the petition, because a lot of the focus today and in the petition was what happens when you have an effect that's not close to what your project is, it's not nearby, and there's some other agency that's regulating it. You
Right.
know, the 11th Circuit case that I mentioned earlier, and came up briefly in the argument today. There was a Corps of Engineers permit to permit a phosphorus mine,
Mm.
and the argument was, well, what about when the phosphorus gets taken over here and processed, and there's waste and it's radioactive? I didn't know phosphorus waste was radio, but it
Yeah, well,
apparently
yeah,
it is.
yeah,
You know, what about that? Shouldn't you have studied that too, Corps? Since you're approving the mine, what about this refining?
right,
And the 11th Circuit said, let those people who regulate the refining process, they can handle that. You don't have to put it in your EIS for this mine. And so I think a lot of what we talked about, what the 11th Circuit did, kind of came back around today in the Supreme Court, and you know, we were kind of emphasizing that it's not irrelevant when there are other regulators out there who can say yes or no to other effects down the line.
right. And I guess jurisdiction is another interesting topic. And I mean, gosh, we could probably spend another 30 minutes on just that. But is there, and again, I feel like, maybe it's just trying to set a line somewhere. Where does the, I mean, because that happens all the time where you're like talking about wetlands and you're not, this is not a core project, but we have wetlands here. Like, how do you sort out where jurisdiction is important and where it isn't?
That came up today. Justice
Yeah,
Kagan asked that very question.
yeah,
You're not saying, are you,
right,
that if you need to fill wetlands to build your project, you don't have to look at that, are you? And the
right,
answer is, of course not.
right.
We're not saying that. But the test that's being proposed, reasonably close in
Close.
terms of time and space plus jurisdiction, works in that case.
Right,
Because you can't, in the hypothetically you presented, Nick, you can't build your project unless you get that permit to fill those wetlands.
right.
It's directly related to the project. It's close in time and space within the jurisdiction of your cooperating agency. They're at the table. It's going
Gotcha.
to be done and studied. No debate about that whatsoever.
Right.
So when the respondents stood up and said, "Oh, we're worried that the agencies are going to turn away the Army Corps of Engineers," for that was actually kind of silly.
Okay.
It was
That's what
silly
I
in
was wondering.
writing, and it was
Yeah.
silly, out loud when they spoke it, because no one was saying that.
Right.
And even the test that we were proposing to the court today to define proximate close would take that into account. So that's not
Gotcha.
going to go away.
Yeah. That's well said too, because I think that was one that I was rummaging around. What does that mean? What are they talking about there? And I appreciate that. So, yeah. So there were two other people that spoke today. So who were those people and why were they speaking?
Sure. Well, the first person was Ed Needler,
Hmm.
who is a Deputy Solicitor General in the Department of Justice. Ed has been a Deputy Solicitor General, I believe, since the Carter administration.
Mm.
This today was his 158th argument, I understand, which
Oh,
is
wow.
the most that anyone has had in modern history.
Wow.
So Ed is an institution,
Yeah.
and he he was there because the United States of America was a party to this case, because the Surface Transportation Board was a party to the case, right?
Okay.
So when we went to the Supreme Court, they kind of came along with this automatically.
Right.
And they had to take a view of, well, do they agree with us that the environmental review was good enough? Or do they agree with the other side that the DC Circuit was right? And they ended up siding with us, maybe for somewhat different reasons, or taking a subtly different approach. But
Right.
they, in the end, agreed with the result, which the result we want, which is to say the DC Circuit was wrong.
Right.
And then the other person arguing today was William Jay, who's an attorney at Goodwin Proctor. I think it was his 18th Supreme Court argument today.
Right.
He's also an excellent advocate, and he was arguing on behalf of Eagle County, Colorado, which was one of the parties that opposed this project, and the Center for Biological Diversity and a sort of assortment of other environmental groups that also had opposed the project.
Yeah, and a little inside baseball on Ed Needler. Apparently, today, not apparently, it's true. His whole family was there,
Oh, really?
including grandchildren and
Oh,
whatnot.
wow.
So it's not going to be on ESPN. And let's look at top 10 plays. Ed Needler breaking the record
Right.
for all
Oh, so
time.
he broke the record today.
Today,
Oh, wow. Okay.
today,
Okay.
he broke that
I
record.
got you.
So, that's not going to be like the headline. But to me, first of all, it's very sweet
Yeah.
that, his family, and it was, and I think it was really important to him as well. He participated in some of the moots, and I talked to him on the side because I knew him from my days at the Department of Justice
Right.
way back when.
Right.
And I think, Jay mentioned this, and I think he's absolutely right. This was a meaningful day for him
Right.
and a meaningful case. He knew it was important. He knew the issues were important, and it meant a lot to him personally and professionally.
Right.
And to see somebody who's been in front of the court, for years and years and years, to have his whole family there,
Right.
including grandchildren, tells you a little something about the passion and the professionalism that he brings to the table. So that's just really nice. I don't know. I don't know how else to say it. It's
That's
just
just a
really
really nice
nice.
thing. So and like in like him speaking today, you don't know what he's going to say, what he's going to argue, or do you have an idea before the case?
And we had some sense of where the United States was. I mean, most importantly, because they'd written two briefs, and so we could read and see, here's what they've been telling the court. And I think you feel relatively confident when you've seen the United States. You know that they're on your side.
Yeah.
And you can kind of get a sense from other conversations of where they might be headed. They're not going to dramatically reverse position and suddenly come up and say, surprise, we're now on
Just
the other
kidding.
side.
Yeah, right, right,
So,
right.
and we at the same time kind of knew that, the United States of America has a lot of different interests in different types of environmental review, and maybe some parts of the government want more and some parts want less. So I think it wasn't a huge surprise for us to see them kind of trying to straddle the fence a little bit, or
Right.
have a test that's a little bit less clear cut than the one that we were advocating. But
Yeah.
I think they, at the same time, conceded that we had some good points.
You're working
Right.
with the Solicitor General's office is an arm's length professional relationship.
Gotcha.
Why? Because they want to win the case,
Right.
but they're not there to advocate for the railroad,
Right.
for the project like we are. They're there to support the Surface Transportation Board's approval, sure, but they also have the interests of the entire government at stake, right?
Yeah.
So there's a lot of things that they have to keep in their heads
Right.
when they make their arguments. If I say this, what does that mean for that?
Right.
And they have to think of the gazillion different variations and hypotheticals. So when we coordinate with them, we're laser beam focused.
Right.
We need to win. We need to get this for our client. They've been working on it for years. We need to win. They appreciate that, but they've,
Yeah. That makes sense.
they've got bigger fish to fry in many ways. And
Right.
so therefore you're not sitting there writing briefs together. It's like we don't see their briefs in advance.
Right.
We do little moots together, but they're not saying we will say this, we promise.
Mm-hmm.
It's an arm's length professional relationship where they know that they're on the same side, they're supporting it, but their job is different
Right.
than our job. It just is. And so therefore, you have this, wink and a nod type relationship sometimes
Right.
with them, but that's as it should be.
Right.
Because they're representing some entity that's very different from the people that we're representing.
Yeah, I mean, I don't even know if I'd go so far as to say there's a wink and a nod. Everything you said was right, that they have their own client and their own interests, and our interests in this case happen to be on the same side, broadly speaking,
Mhm.
but
But it could have been the other way
we don't
around.
control what they say for sure.
And I had noticed the justice, I can't remember who it was like, it doesn't sound like you disagree, which is one of my favorite phrases to say. It's like, you make me think for half a second. Okay, yeah, okay, cool. So is that because they're trying to say, well, you guys, if you're agreeing, why won't you just say that? Or is it, why would they even put that out there?
Yeah, I mean, I think that was all about, a series of questions about the test that we proposed, right?
Right.
And I believe it was Justice Kagan who said something along the lines of, okay, well, if your test is different, give me an example of a situation
Right.
where your test would have a different result than, the 7-county test, the Clement
The
test.
Clement test. I was about to say, I was
Yeah.
going to call you on it.
The Clement test.
You're right,
And
right.
and I think that Ed struggled to come up with a concrete example. I mean, it's not easy when you're on your feet and you get a question that specific.
Right.
You
Right.
know, maybe if you'd given him a little more time to think of it, he could have come up with some examples. But I think the reason that she said, well, I don't think you're disagreeing is because it sounded like no matter how you worded the test, our way or their way, it had the same result.
Interesting. Okay, so that brings us to the last part. So, when Eagle County talked, how do you think that went, and what were your takeaways from that?
Well, I mean, I think that their counsel did a good job. I mean, he made the points that he needed to make, given the argument that he was defending. You know, I really do think that when you get to the Supreme Court, there comes a sort of like, okay, you guys have been in the weeds for 5 years, but we're
Yeah.
coming at this fresh. And boy, it seems weird that you had to study those effects way down there in Louisiana.
Right.
What's going on with that? And
Right.
that's a hard one to defend. And he did the best he could. And I think in part he pointed out that one of the members of the Surface Transportation Board had dissented from the decision to grant us authority to build this railroad. And so he sort of said, well, look, this, I think his basic point was, hey, this project's all about the oil. And the Surface Transportation Board was making a decision to allow the oil or not. And so it should have considered all the effects of the oil.
Right.
That's when all the questions about common carrier and, well, could they really refuse the oil and all those sorts of
Right.
things came out. But I think that was, maybe you have something more to add, Fred, but I think that was kind of his bottom line is like, you really got to focus on the oil. And, you know, maybe this case is different from a lot of other cases. He said that a few times, like,
Right.
you know, this is a special case because it's so focused on oil, which, just as an aside, this case is not entirely about oil. I
Right.
think I understand why he said it that way, but, you know, yes, there would be oil coming out of this train, but there would also be minerals and there would be wheat and all sorts of other things. You know, there's lots of human beings who live in the Uinta Basin,
Yeah.
and they're not all oil producers. You know, there's farmers and ranchers and all sorts of other people who live there. And, you know, the reason we want to build this rail line is to help everyone, not just to get things out, but also to get things in.
Right.
You know, it's not easy to get there. There's like sort
Yeah.
of 2-lane roads over big mountains. It
Yeah.
snows in October, you know, crazy stuff
Right.
from an East Coaster perspective, at least.
Yeah.
And so, and the thing I said in the DC Circuit argument too is, you know, when you build a railroad, it's there for 100 years.
Right.
Like, so maybe the first 20 years is a lot of oil trains, but after that, there's a lot of other stuff.
Right.
You know, and even before the 20 years is up, it's an economic development engine, and that's what the people in the basin are looking for.
Yeah, if this was a trial, which it's not,
Right.
you
Right.
know, you would have the urge to stand up and say, I object.
Right.
It's not
Right,
just an
right.
oil train. I mean, that's, of course, you want to portray it as that, but it's clearly not that. I think he and they in general were in a tough position.
Okay.
Think about it. Put yourself in his shoes for a sec. You know, you challenge it and you get this, you know, victory in the DC circuit. You're going to send him back to, you know, Monopoly, do not pass go, do not
Right.
collect $200.
Right.
Start, you know, do more analysis. You know, you think you got a win in your pocket because, you know, are these guys really going to do that? Are they
really
going to
gonna
take
see
the
this
time
case
and
now?
money
Yeah.
to
Mhm.
to do all that? And then they oppose cert. They told the court not to take the case. And then all of a sudden cert's granted.
Right.
So when, hey, we're really happy, this could take forever, to uh-oh,
Yeah.
our win's in jeopardy, to uh-oh, you know, now we're not just defending, you know, the DC Circuit opinion, which is a little bit funky.
Right.
We're defending a kind of funky decision, but now we have to also answer some of the broader issues about, you know, how NEPA is sometimes, you know, malfunctioning and what does that mean?
Yeah.
So you're defending a whole bunch of stuff that in many ways defies common sense.
Right.
Congress has acted to try to, you know, reform NEPA. There's a lot of things going against you if you're on the other side. And
Yeah.
so it's tough. You know, you've got cert grant, which means that 4 justices, you know, already
Yeah.
think that there's a problem here.
Yeah.
So the other side definitely, if you just asked me who had the harder argument to make,
Right. It's Eagle
I
County.
think it's clearly it was them compared to us. Now we had a hard argument to make because we had to define the test and all that kind of stuff. It wasn't, simple. But of the two sides, I think, theirs was harder from the outset because of the posture of the case
Very
in front of the court.
right.
Yeah, well, I mean, I think the stats say that something like 2/3 of all the cases that are granted get reversed. So, I mean, it's you start out behind the 8 ball if you're the respondent.
Got you. Interesting. That's interesting. And it's funny. So we actually do have a couple of questions from the audience. Gosh, I don't want to derail too much from this, but to wrap this up, then, are there any other thoughts on the case itself that we want to get out before we start answering? I've got two questions from the audience.
I'm ready for the question.
I'm ready for
All right,
question
all
two. I would just say this is just going to be a piece of all the moving NEPA parts that are out there. The CEQ regulations under Marin Audubon, the review of the phase 2 NEPA rules,
Ooh,
the
yeah.
new administration coming in, what are they going to do? So, there's a lot of moving pieces. And one of the things I think about this case, Nick, is that this could help frame a lot of resolution of all those things in 2025.
Yeah.
NEPA's exciting now. It used to be boring.
Yeah, 50 years, nothing happened. Now it's very exciting. So that's
Yeah.
what I think. So what does the audience say?
So, okay. But yeah, remind me, Marin Ottoman, I'm going to come back to that. But first things first is another terminology question. So this one's a softball. What was the deal with all the discussion of the organic statute? Is that referring to NEPA or something else?
Yeah, that's when you're a practitioner and instead of going to Safeway to look up the law, you go to Whole Foods.
All right.
That's all it is.
Okay.
It's just where you find the library book.
Okay.
No, that's not.
Nothing too.
No, it was the organic statute that they kept talking about is the statute that gives the STB the power to authorize the railroad in the first place. In this case, it's called the ICC Termination Act. So it's kind of a long name.
Oh, wow, yeah.
And it's easier just to say organic statute. And what the court means when they say that is just the statute that the agency is acting under. NEPA is kind of this procedural overlay, right?
Right.
Everybody has to do NEPA, but each agency has its own organic statute under which it acts.
Gotcha. That makes sense. Yeah. And so I've got another question on so I guess the Kavanaugh statement is what we'll call it. So I have a question asking, he says, well, why does NEPA even matter? Neither one of you seem to be overly concerned with the statement. Is it just a throwaway line? Is it threatening? I guess some people are wondering, do we have to worry that NEPA is going to be under a big challenges coming up? Stuff like
Well,
that.
I think he was just being provocative in some ways. I don't think that's not what this case is about. Maybe I don't. Who knows what's going through Justice Kavanaugh's head precisely, but
Right.
but I don't foresee a decision that says, oh, guess what? NEPA doesn't matter anymore.
Yeah, and that's the difference between Justice Kavanaugh and Vivek Ramaswamy.
Right.
He may look at something like that and just be happy to throw out the baby with the bathwater as a political matter, but no, from a legal matter, I think he was trying to put the statute in its proper context. If I were standing up there, I would have said, no, justice, it definitely still matters. It's the umbrella statute by which all these things get analyzed and organized in a way that the agencies, plural, the lead agency and the cooperating agencies, as well as the public, can better understand what the federal government does.
Right.
That's its role.
And I think that is what we said, basically.
Yeah.
Maybe not in those precise words, but
Yeah.
Yeah, but it still has meaning.
Yeah.
And so no, I don't think there's any threat in that regard. I totally think it was a provocative question to a certain extent, and we didn't, to our credit, we didn't take that bait.
Right. I was about to say, yeah, you didn't. So, okay, you mentioned the Marin Ottoman case. No one raised that today either. Why not?
I was a little surprised, I guess. I thought it might come up. It was in the amicus briefs, at least two of the amicus briefs,
Okay.
not Marin Audubon itself, but the concept that the CEQ doesn't have authority to issue binding rules. And I think there was one point at which Paul even mentioned the CEQ regulations and how they were originally intended for one thing or another, and nobody asked about it. So, I guess I would take that to mean they'll say they're saving that one for another
day. Yeah.
I think probably, well, Fred, I'm sure knows, but the United States has filed a petition for rehearing en banc in the DC Circuit in that case,
Yeah.
and so has the party that won. So everybody wants that to be heard again by the DC Circuit.
Yeah.
DC Circuit doesn't usually hear cases en banc, but including our case, we asked for that and in the Seven County case, and they didn't
So,
grant it.
yeah.
But if the government's asking for it and the party that won's asking for it, there's a decent chance that it's going to get reheard, and then we'll see. What
I think that's why
happens.
they didn't talk about it, because they were aware of that.
Yeah.
And there's a lot more that has to play out, including the potential that that ruling could be overturned by
yeah.
en banc.
That's right.
And so why even meddle in that right now? You know, when the party that won the case seeks rehearing, and they're basically telling the DC Circuit, yeah, we wanted to win, but we didn't want to win that way.
Right.
Exactly.
That's really, that's kind of remarkable.
Yeah, it is.
So
Well-
my sense is that, yeah, I was surprised to a certain extent because, you know, put it this way, if Justice Gorsuch were still hearing the case, if he hadn't recused himself, I think he would have asked about that.
Yeah.
Gotcha.
But no, in some ways I wasn't surprised because a lot has to play out. The DC Circuit's already asked for more briefing on the topic, which won't be concluded till the end of this month.
Right.
And then if they take it, then there'll be just, you know, argument, and then I'll take time, blah, blah, blah. I think the Supreme Court said there's a lot of more chapters to be written
Exactly.
in that case. So, you know,
Why even bother?
why
Right.
try to write the end of the book when
The
it's still
Supreme
being
Court's-
written?
It's
Yeah.
a long game, right? The justices aren't in any rush to decide things. They don't typically take the first decision that comes out that does something, you know, unusual and say, "Oh, now it's
Yeah.
our chance." The cat's out of the bag on the
Right.
CEQ rules. You know, people are going to keep making this argument. Other courts are going to decide it. Maybe some courts will decide it in cases where it's actually briefed in detail. And eventually you'll probably get another kind of circuit split
Yeah.
like we had in our case. And at that point, then maybe you'll see the Supreme Court come in and say, okay, now we're going to
let's sort
figure
this
it
out.
out.
Yeah, the Supreme Court and its personality is pretty much like the difference between Jay's personality and mine. Jay is the thoughtful, long game. It's all going to play out and whatnot.
Right,
I'm the
right.
kind of like more political, like, oh my God, what did they do? What's going to happen? You know, blah, blah, blah. And, you know, and Jay's the person who says, you know, Fred,
Even
that's
keel,
interesting,
yeah.
but you know what? Let's chill. Let's see what's going to happen.
Right.
And Jay's personality is very much like the way the Supreme Court operates, which is, that's nice. I'm glad it's out there. We'll all take it in stride.
Yeah.
And eventually we'll see what happens.
Yeah. I know no one can see it, but Jay agreed. I just want to.
I hadn't been analyzed like that before, but I guess
He's like, well,
you know,
yeah.
Well,
I'm laid back.
Yeah.
you should be analyzed.
He
that
didn't.
way.
He didn't say Fred's dramatic. I'm saying that, but that was great.
That's
That
what
was
makes a
well
great
done.
partnership.
Yeah,
you,
does,
you
it
need to
does.
approach arguments and
In
views
different ways.
from different ways, and then
Yes.
it comes together like a symphony.
All right. Yeah. So I mean, I think that's great. What a great conversation we've had today. I'm gonna close with where do we think things are gonna go next, and then I'll save our last fun question for Jay. But go ahead. Where are we going next?
Well, I think you'll see a decision in this case May-ish, April, May, June, somewhere in that time frame.
Okay.
Where then the question is sort of twofold. One, where does the Uinta project go? And I think the answer is it'll go back to the board and we'll try to get it built.
Right.
Where everything else in NEPA world goes, it depends on what the court says exactly. I mean, we'll go back and try to get it built, win or lose, I guess, just to be clear.
Right.
Because even if we had the DC Circuit's decision, we were able to go back and do more NEPA and go back and fix the problems that the DC Circuit identified.
Right.
It just takes a lot longer.
Right.
Hopefully, if we get what we're asking for, we go back with the NEPA box checked, and then we can move forward.
Very cool.
And I don't know, Fred, maybe you want to venture some predictions on
I was about to
NEPA
say.
more writ large, but
Yeah, no, I think predictions on the case itself is generally what counsel doesn't do.
Yeah, I was about to say the same thing.
Because this
Yeah,
isn't
yeah.
like who's going to
Yeah.
win the game on Sunday.
Right, right.
If you make a bad prediction that way, all right, you're with the whole
Yeah.
world that doesn't know how to predict it. But when you try to make a prediction,
Yeah.
if part of your legal job, that's
Very different.
we try to avoid that.
Yeah, that makes sense.
One thing I will say that I think is pretty clear. That you remember the Sackett wetlands
Yeah.
ruling.
Mhm.
It was unanimous
Yeah.
that nobody liked the significant nexus test anymore.
Right.
Nobody liked it. Yeah, the decision came out in a different way in terms of how they analyzed it, and there was dissents and stuff like that. But nobody liked the significant nexus test. I didn't hear anybody on the bench today saying that they liked the DC Circuit ruling.
Right.
Nobody liked it.
Right.
And so I think, in my sense, a lot of what we may see sort of builds off of that.
Okay.
If they went too far and some of their conclusions were too far, where else do we go? Because I didn't hear anybody saying, "Oh, I think what the DC Circuit did was perfectly fine. Why are we here?"
Right.
Yeah.
So that's one reaction that I have. And again, how it's going to turn out and what the breakdown will be, we don't know. The big question in my mind, Nick, is with the new administration coming in, how quickly or not are they going to act on NEPA in general?
Right.
And Jay and I have talked about it, and we've written about it. And I think to a certain extent, if they were rational,
Mm-hmm.
they would wait.
Right.
They would hold their powder on issuing new regs, rescinding regs, whatever, because they may get a lot of help
Right.
from both the Supreme Court as well as the courts that are reviewing the Phase 2 rule right now.
Right.
They can get a lot of help, and they can save themselves a lot of time and energy. They can save themselves a lot of headaches to say, look, this is what the courts have instructed us, both in terms of the validity of the proposed rule as well as what the Supreme Court has said about how to define the scope of analysis.
Yeah.
And we're going to craft our rule consistent with that guidance.
Right.
And that would only prevent them from taking action for a matter of 3 to 4 months,
Right.
really, after they take office and figure out where the restroom is,
Mm-hmm.
or re-find out where the restroom is, depending who we're talking about. So,
Right.
I mean, I think that there may be a tendency to want to do something fast, fast, fast.
Right.
But there's a possibility that when they think about it a little bit, they may say, wait a minute, there's people out there that may help make our jobs a lot easier. Whether that view of the world will carry the day,
Right.
who knows?
Who knows?
That I will not predict. But
Right.
there is an argument to be made that they don't have to act quick. They can
Right.
take some time and hear how this shakes out.
Gotcha. Very cool. Well, so this has been live. This has been really fun to do live. The actual recording will go up probably not this Friday, but next Friday as well on our podcast stream, so you guys can all hear it again if you missed anything. But last but not least, we always end the show asking what people do for fun. We've heard from Fred plenty.
Right.
So Jay,
Does he tell you something new every time?
yeah,
or-
you could pretty much, yes, actually. He told us one of my favorite stories he ever told was about going to an F1 race and how he even got there without speaking any Italian. So, I mean,
Wow.
that's Fred. But so when you are not doing, preparing for a Supreme Court case, what do you do for fun?
All right. Well, I've been to a few NASCAR races in my younger days,
There you go.
but I haven't done that in a while. I'm from East Tennessee, so there's a big track there, Bristol.
Oh, yeah, yeah.
So I've been to a number of those races, but haven't been to a race in a while. My favorite sort of leisure time, I guess, would be baseball.
There we go.
I love baseball. I've become a big Nats fan. I've had season tickets since they moved here in 05.
Oh, wow.
It's the 20th year
Yeah.
this
Oh,
year for
gosh,
the
yeah,
Nats.
that's right.
So
Yeah, they
love
gave you
going
a
to
World
baseball
Series a couple
games.
years ago.
Yeah,
so-
I mean, going to World Series games, one of the coolest things I've ever done. Beyond that, I've got 3 kids. They keep me busy.
There you go.
One last thing.
Yeah,
Nick,
sure.
The audience can't see it, but one of the coolest things of the day,
Mm-hmm.
and it's a little thing that you don't know about really. You get to the desk where you're doing the arguments, Jay and Paul, and then the other side, and there are these quills sitting on paper in front of on pads
Yeah,
in front of the podium,
yeah.
and this is your keepsake to
Oh, wow.
take back as a memento of the argument and your briefing in the U.S. Supreme Court. And I'm holding one of them that Jay so kindly gave me. There were 2 on the desk, and Paul
Wow.
Clement says, I have a few of these, 118. Ed Needler,
right.
I've got a few of these,
yeah.
158.
Yeah,
But
right,
we,
right.
we ain't got them.
Right.
And so we're going to walk away, hopefully not just with a positive ruling for our client, that would be the most important thing, but walk away with this memento, which is, we'll both cherish,
Yeah.
for the rest of our days. Hopefully we'll have more opportunities to do that.
Right.
But this is a great keepsake and great memento of the day. So when people see me at NAEP at the conference coming
Yeah.
up, or other friends who see me, I'm probably going to have this frame next to a picture of Jay and me in front of the Supreme Court
There you go.
that my wife took. But that's a cool little memento of the day.
That's very cool. Well, thank you both for your time. I really appreciate that. I know you've had a very long day, and we are wrapping it up. So again, I can't say enough how much I appreciate you taking the time to talk with us.
Yeah, our pleasure. Thank you.
We'll be talking more when the decision comes out.
I know it. I can't wait.